Hello, friends. I feel it is my proud privilege to talk to you through this video lecture. As all of you know that because of time paucity, I may not be able to cover all the syllabus in the classroom itself. And some of the students who have gone for the tour may not be able to attend the class during these hours. Hence, in order to help you all, I am preparing this video lecture series for this Unit 6, that is Intellectual Property Rights. Friends, all of you know that intellectual property right is introduced as the second part of your subject, that is research methodology and intellectual property rights. The first part, we have already covered many things in the research, and the last point is protecting the research outcomes in the form of intellectual property rights. And you should be able to know what are the intellectual property rights, what are the characteristics and all that. So in order to create an awareness among the students who conduct the research to protect their research outcomes, intellectual property right unit is introduced in this subject. Let us understand today some things relating to intellectual property rights. Friends, as a part of the subject, many things I have to cover in the syllabus. The main important discussion points through this lecture series I'm going to cover is meaning and concept of intellectual property rights, nature and characteristics of intellectual property, origin and development of intellectual property, kinds of intellectual property in system in India, IPR's invention and creativity, intellectual property importance, and protection of intellectual property rights, a brief summary of patents, copyrights, trademarks, and trips and trims, industrial designs, that is circuits, geographical indications, establishment of WIPO application and procedures. I welcome you to my lecture series 1, lecture 1 on this Unit 6 intellectual property rights. Today I am going to discuss with you the concept, meaning and characteristics. This lecture series will only focus on concepts, meaning and characteristics. Let us understand what the intellectual property is. The intellectual property rights provide a legal protection for intellectual creations of the human mind. These rights are fundamental to modern economies, encouraging innovation, fostering creativity, and driving economic growth by allowing creators to benefit from their intellectual efforts. As you know, the intellectual property or intellectual quality asset is an intangible in nature. Any tangible asset is there, you can protect it by fencing it or keeping it in a safe place. But the intellectual property cannot be kept in a safe place unless and until it is protected by law, unless and until it is given certain authority to the inventor or generator of intellectual knowledge to protect through the enforcement of law. That is why intellectual property right is most essential. As it is mentioned in the concept clarity itself, that intellectual property is an intangible asset. It is created out of the human mind. Anybody who creates the intellectual property or intellectual idea which is most useful for the society, the inventor must and should get use of that. He may be discovering a fact or inventing a fact. It may be innovation or invention, whatever it is. As all of you know, there is a difference between innovation and invention. Invention is the first-hand knowledge that is created by the scientist through his efforts. The first person who creates an idea of that particular is called as an inventor, or he is called as scientist. Innovation is a combination of two different available factors and creating a third new one. It's called as discovery, what we call as innovation. Both inventions and innovations are the generations of an intellectual mind. Any person through his intellectual ability creates certain kinds of assets like this. Outcomes need to be protected in order to benefit for himself. If at all any kind of thing is created by a personal invention, by putting time, effort, and money for generating or discovering certain kind of an idea, if it is taken away by a third person without any kind of effort, then the copying of such kind of things may create easiness to others and snatches away the rights of the person who has invented it. Therefore, in order to provide certain kind of economic benefit and encourage innovations and protect the innovations to the creators and to benefit, this intellectual property right has been introduced in the world. This IPR is not only introduced in India, but it is also introduced throughout the country, throughout the world. Today, being a globalization, when many countries come together on a common platform of innovations and development, any country who creates a new idea need to be protected at the international level also. So the IPR is not only governing at the local levels of the country, but also at the international levels also. So the rules and regulations of IPR at the national level, international level, and at the foreign level, they are different. The intellectual property rights, what are there in India, may not be the similar in America or in Europe or in other countries. And when all these countries mix together and transact on certain common platforms, then intellectual property rights are to be protected at the international level. When two countries mingle together, so at the world level also, there are certain kinds of setups made. So intellectual property is the most essential requirement to protect the knowledge and the ideas created by the innovators or discoverers. What is the meaning of and characteristics of intellectual property rights? Meaning, if you consider, intellectual property rights are the legal protections granted to creators and innovators over their intangible assets. These rights give creators exclusive control over the use, reproduction, and commercialization of their work for the specific period. It means that any person who invents a new idea or generates a new concepts, he can use it himself without his permission, the inventor's permission. Third party cannot use it for a specific period of time. That is what we call as protecting the intellectual rights. Any laws governing to protect the knowledge creations of an inventor or discoverer not to be copied or taken away or used without the consent are being prohibited and protected under the law. That is called as intellectual property rights. That is called, it is the right that is automatically generated with the inventor when he gets new product, new idea, because that rights remains with him because he is the generator of the new idea. He cannot, he, without his consent, without his knowledge, or without paying money to him, if he is expecting the monetary reward, it cannot be used by the third people and it is prohibited under the law. That law is called as Intellectual Property Rights Acts. IPR ensures that creators can prevent unauthorized use of their intellectual property without permission or compensation, therefore protecting the value of their creative or innovative efforts is called as intellectual property rights. It means that intellectual property rights protects the innovators against the duplications, wrong use, or without knowledge commercialization of that particular knowledge is prohibited. If the creator or the owner of the idea wanted to sell it, he can sell it through a legal procedures. Then only the third party buying that can use it. That is how the protection of the rights of creation of a knowledge or a product or an idea is called as intellectual property rights. Let us understand the characteristics of intellectual property rights. There are basically 5 different types of characteristics. In this slide, I'm going to discuss the 2 important characteristics. The one is intangible asset. Remember, intellectual property rights is always protecting the non-physical creations such as inventions, literary works, artistic expressions, designs, logos, and software. Unlike a physical property, intellectual property can be used by multiple parties simultaneously. As you know that the physical products have got usage by many people. So, a creator of a knowledge, what you call as non-physical in knowledge, literary works or inventions, artistic expressions, and all that can be protected under intellectual property rights. So, the intellectual property right is only applicable for intangible assets. That is what we call as IPRs. For example, today this computer world, when the computer is created by Charles Babbage, if he is alive, he could have protected the usage of the computers by the third party. Anybody who is using the concept of Charles Babbage's computers must and should have paid to him, and they have taken that idea from the owner himself. That is why it was, but it is not possible that the person is not there now, and the time of that intellectual property has also been expired. Therefore, there is no what do you call as intellectual property right prevails in the computer concept. For example, a Dell computer uses a specific software for protecting certain kinds of files or for executing certain kind of activities. Then Dell computer has all the rights to protect it. Without the knowledge of the Dell computers, third company cannot use it. That is what intellectual property right protection. It is a intangible in nature. Second important characteristics is exclusive rights. The owners hold exclusive rights to use, reproduce, redistribute, display, and modify their intellectual property. It means that intellectual property rights gives an idea to the owners only that they can protect the usage by the third party. They themselves can use it. They themselves can distribute it. They themselves can display and modify the ideas or their intellectual property things. Third party cannot do any kind of things relating to that. That a third party cannot distribute, display, modify, or reproduce the owner's innovations without their knowledge or without giving them a reward, taking the permission from them. For example, if the Dell Computer wanted to sell its new concept of modifications in the computers to any other company. If it wishes, it can sell it. So when it sells, it loses the rights of that intellectual property. Third party can use it. Sometimes they can restrict the sale only to one party and restrict the sale to a third party. For example, if Dell Computers sells the software to XYZ company, computer company, only XYZ company can use that particular software. No other company can do it. That is how the intellectual properties rights can fix up the rights of the original manufacturers of the products. The third important characteristics is territorial in nature. The intellectual property rights have got the scope of a particular territory. For example, in India, if the product is produced by an Indian inventor, scientist, or a discoverer, Indian jurisdiction only will be the protection area. If it cross borders, if it enters, he doesn't have a control on that. That the inventor has no control on the duplication, reproduction, and utilization. If at all, the person wants to cover the cross borders also, a special rights have to be generated at the international level to protect the rights, which the procedure is very lengthy. So normally, intellectual property rights, given an option, has got a jurisdictional area within which it can be protected. And remember, important point of this intellectual property right characteristics is time limitation. The intellectual property right cannot be held for many years together. There is a maximum period of time mentioned at the time of giving the intellectual property the position. For example, an inventor who discovers a copyright or a particular generated article, the article can be protected for 5 years or 10 years depending on the situations. After that particular time, it becomes quite open. Any party can use it, because if intellectual property rights are not given a time limitation, None of the knowledge will come to the help of the open public. Many open public wanted the knowledge at the cheapest cost or at no cost. Therefore, sometimes the knowledge that is generated is most essential for the public also. That is why the time limitations are given. For example, a newly introduced cancer drug called ibrutinib for a special cancer disease was invented by Americans. They held that particular rights for 10 years. After the 10th year, they released it to all developed countries at a free cost. When this drug is given the molecule at a free cost, all Indian pharmaceutical companies started manufacturing these drugs and started selling. So the patents were at a cheaper cost acquired by Indians and started manufacturing. This is what time limitations. If they held this for the long time together, 100 years, then many people, mankind, may not get the use of this cancerous drug and save their lives. That is why, in order to protect the interest of the public and also to balance the interest of the discoverers, certain time limits are provided under intellectual property rights. That is one more important characteristics. The next important characteristics is economic value. All ideas cannot be patented or cannot be copyrighted and all that. Only the ideas which have got economic value can be put under IPR. For example, you have an idea of giving a jokes or singing a good song. That cannot be patented because this is not an economic value. But if you compose a music which is very much creating a value to the people, then you can patent it. Only the people who pay the money can download that particular song and use it. That is what we call as economic value. If assets drive business competitiveness and can represent significant portion of a company's valuation, then only they enable business to distinguish themselves in the marketplace. So when the idea generated by the discoverer, if it is implemented, can generate the business outcome and is having a economic value, those kinds of ideas, those kinds of intellectual knowledges can be patented or can be under the control of the intellectual property rights. If any idea generated doesn't have economic value, that cannot be covered under intellectual property rights. So friends, thank you very much for watching this video. In this video, I have I have discussed what is the concept of the intellectual property rights, what is the meaning of the intellectual property rights and characteristics of the intellectual property rights. In the examination, direct question may ask for 7 marks or even for 10 marks. What is intellectual property rights? Discuss the characteristics of intellectual property rights. Hope this video will help you for preparation in the examinations, and thank you very much for your patience listening. Thank you. Thanks for all.